Picture this, you've finished your manuscript and you're thrilled, exhausted and maybe a little terrified about what comes next. Somewhere between celebrating and panicking, a nagging worry creeps in. What if someone steals my work? If you've ever wondered, do I need to register my copyright? How do I actually protect my book from plagiarism? You're definitely not alone. I hear these questions constantly from authors, and honestly, the confusion is completely understandable. Copyright law can feel like navigating a maze blindfolded. Maybe you've heard conflicting advice about whether the rules are different between the UK and the USA, or you're unsure if you need to put that little C symbol in your book. Perhaps you're worried about sharing your work online with beta readers, publishers, before it's officially protected. Here's the thing, copyright protection is actually much simpler than most people think, but there are some crucial details that can make a real difference to your peace of mind and your legal standing. So today I'm going to give you clear, straightforward answers to all these questions, focusing specifically on the UK and the US copyright law, since those are the jurisdictions most of you will be dealing with. Let's start with the basics. Copyright is essentially your legal ownership of your creative work. It's what gives you exclusive right to decide how your book is used, copied, distributed, or adapted. Think of it as an invisible shield around your work that says, this belongs to me and you can't use it without my permission. Here's the most important thing to understand. Copyright protection begins the moment you create an original work and fix it in some tangible form. That means as soon as you type that first sentence and save your document or scribble your story into a notepad, you automatically own the copyright to that work. You don't need to file paperwork, pay fees, or perform any specific rituals. The protection is instant and automatic. This automatic protection applies to literary works, which includes novels, short stories, poetry, articles, and even blog posts. It covers the specific expression of your ideas, the particular way you've arranged words, developed characters, and structured your plot. However, copyright doesn't protect abstract ideas themselves, only the way you've expressed them. Your copyright gives you several exclusive rights: the right to reproduce your work, distribute copies, create derivative works like adaptations or sequels, and perform or display the work publicly. Most importantly for authors, it prevents others from copying substantial portions of your work without your permission. But here's where things get interesting. While the basic principle of automatic copyright protection is similar, both in the UK and USA, there are some important differences in terms of how you can enforce those rights and the additional protections that are available to you. Let's break down each jurisdiction. So starting with copyright in the UK first. Here in the UK, copyright law is refreshingly straightforward. Your work is protected automatically from the moment of creation. No registration required, no fees to pay, no forms to fill out. The UK recognises literary works under the Copyright Designs and Patents Act 1988, which has been updated over the years but remains the foundation of copyright protection. Your copyright in the UK typically lasts for your lifetime, plus 70 years after your death. This means your heirs will continue to benefit from your work for decades, and your book won't enter the public domain until well into the next century. For works with multiple authors, the 70-year period begins after the death of the last surviving author. The UK system covers all forms of literary work, whether published or unpublished, and regardless of literary merit. So yes, even that vampire romance that you've been secretly writing is fully protected. The key requirement is that the work must be original, meaning it originated from you and wasn't copied from someone else. And it must demonstrate some degree of skill, judgment, or creative effort. If someone infringes your copyright in the UK, you have several options. You can send them a cease and desist letter, seek an injunction to stop the infringement, and claim damages for any losses you've suffered, or even seek to recover the profits the infringer made from using your work. The UK courts take copyright infringement really seriously, and you don't need to have registered anything to take legal action. One thing that often surprises authors is that you can take action even if the infringement is partial. Someone doesn't need to copy your entire book to violate your copyright. Taking a substantial part of your work, even if it's not the majority, can still constitute infringement. The UK also has a concept called fair dealing, which allows limited use of copyrighted material for purposes like criticism, review, news reporting, or research. However, this is much narrower than the US concept of fair use, and commercial use rarely qualifies as fair dealing. Now let's talk about US copyright law. It operates on the same fundamental principle, automatic protection upon creation, but offers additional benefits if you take certain steps. So just like the UK, your work is protected the moment you create it, and copyright generally lasts for your lifetime plus 70 years. However, the US system provides a significant advantage: voluntary copyright registration with the US Copyright Office. While registration isn't required for basic copyright protection, it's incredibly valuable if you ever need to enforce your rights. Registration costs between $45 and $65 depending on how you file, and it provides several crucial benefits. First, registration creates a public record of your copyright claim and provides legal evidence that you own the work. More importantly, if you register before infringement occurs or within 3 months of publication, you become eligible for statutory damages and attorney fees if you win a copyright lawsuit. Without registration, you can only claim actual damages, which can be difficult and expensive to prove. Statutory damages can range from $750 to as much as $30,000 per work infringed, or up to $150,000 if the infringement was willful. When you consider that proving actual damages often requires expensive expert testimony, detailed financial analysis, those statutory damages can be incredibly valuable. The US also provides additional digital protection through the Digital Millennium Copyright Act. This allows you to request takedown of infringing content from websites, social media platforms, and online retailers relatively quickly and without having to go to court. Most major platforms have streamlined DMCA processes that can remove infringing content within days. The US fair use doctrine is broader than UK fair dealing, considering factors like the purpose of use, the nature of the copyrighted work, the amount used, and the effect on the market for the original work. However, fair use is still quite limited, and commercial use of substantial portions rarely qualifies. For US authors, I generally recommend registering your copyright, especially for works you plan to publish commercially. The peace of mind and legal advantages far outweigh the extremely modest cost. Now, I'd like to address some myths I hear constantly. First, you absolutely do not need to put a copyright notice, the C in the bubble, in your book for protection. Your copyright exists without this. However, including a notice is smart because it informs readers that the work is protected and can prevent someone from claiming that they didn't know it was copyrighted. The format is simple. It's that little C in the bubble that we all know. You then put the year and then you put your name. Some authors include all rights reserved, but it's not legally necessary in most jurisdictions. Another common misconception is what's known as the poor man's copyright, which is where you mail yourself a copy of your work. This actually provides no legal benefits whatsoever, so don't waste your stamps. Many authors worry about sharing their work with beta readers, critique partners, or editors, or publishers before it's officially protected. Remember, your work is automatically protected from the moment you create it. So sharing it for feedback is perfectly safe from a copyright perspective. If you're concerned, you can always ask readers to sign a simple non-disclosure agreement. Regarding fair use and fair dealing, these concepts allow limited use of copyright material, but they're much narrower than most people think. A few sentences for review purposes, probably fine. A paragraph for criticism or commentary, most likely acceptable. Entire chapters in your own book, that's definitely not fair use. And one question I get asked frequently is whether copyright protects my story ideas. The answer is no. Copyright only protects the expression of ideas, not the ideas themselves. So, for example, you can't copyright the concept of vampires in high school or a detective solves murder, but you can copyright your specific story with your unique characters, plot, and prose. Finally, many authors ask about international protection. Both the UK and USA are parties to international copyright treaties, meaning your work is generally protected in most countries worldwide without any additional registration. And if you're watching from Canada, Australia, New Zealand, or elsewhere, the good news is that most developed countries follow similar principles of automatic copyright protection. However, specific enforcement mechanisms, registration benefits, and fair dealing provisions can vary significantly. I'd love to hear from international viewers in the comments. Let me know which country you're writing from and whether you'd like me to cover copyright law in your jurisdiction in a future video. If there's enough interest, I can definitely do a follow-up video. And any other questions that you have on UK copyright law, US copyright law, or anything that I didn't cover in this video, please do comment down below and I will have a look for you. So let's quickly recap the key points. Your copyright protection is automatic from the moment you create your work, whether you're in the UK, USA, or most other countries. You don't need to register anything for basic protection, but US authors should seriously consider registration for the additional legal benefits it provides. Including a copyright notice in your work costs nothing and it provides additional protection for you. And don't worry about sharing your work for feedback. It's already protected from the moment you started writing. And remember, copyright protects your specific expression, not your underlying ideas. Ultimately, the most important takeaway is this: you're already more protected than you probably realize. Copyright law exists to support creators like you. And while the legal details can seem overwhelming, the basic protection is robust and automatic. So I hope this video has cleared up some of the confusion around copyright for authors. If you have any specific questions about copyright or other legal issues affecting writers, drop them in the comments below. I will do my best to read every single one. YouTube will now be recommending another one of my valuable videos right here, so go ahead and watch that one next.